Good evening, everyone. This is the second episode of the RFC Tuesday podcast, Season 9. My name is Ryan Daes. You can call me Kuya Ryan. And I am a registered financial consultant, a registered estate planner, and a chartered wealth manager. This podcast is made possible through the concerted effort of IARFC Philippines and IARFC head office in Ohio, USA, represented by their ever efficient and ever reliable Miss Susan Capa, the IARC's Public Relations Officer. The IARC Philippines is an association dedicated to the craft of financial consulting. The association is the sole organization authorized to conduct the RFC conversion courses as well as continuing education in the field of financial consulting. Professionals from the life insurance and financial wealth management industries usually pursue greatness and fame to make names for themselves. But our guest for tonight has a different passion. His aims are prudence, proficiency, and integrity. His main goal is his fiduciary duty. David Kinder is a veteran of the insurance and financial services industry. He has served the needs of American residents and business owners, currently as a financial consultant with unconventional strategies to help them accomplish their retirement income and wealth accumulation goals. David studied advanced financial planning through his various studies with the American College of Financial Services. He took private university level courses for over 2 years and passed over a dozen exams, proving his mastery and expertise in financial planning subjects such as investments, retirement planning, income taxation, insurance matters, estate planning, and planning for business owners. He has an ethics approved status, a recognition through the IARFC. Ethics approved status means adherence to the IARFC Code of Ethics with a clear record for the past 5 years. Members are biennially verified through FINRA, state licensing records, internet searches, and are required to pass the ethics exam. So he's a very squeaky clean guy. So you won't find any bad record online about him. He's also a chartered financial consultant, an advanced financial planning designation from the American College of Financial Services, focusing in the areas of financial planning process, insurance, income taxation, retirement planning, investments, and estate planning. He also holds a designation of Chartered Life Underwriter, which is the premier insurance designation from the American College of Financial Services. It adds additional education and expertise in the area of individual life insurance law, planning for business owners and professionals. David is a recipient of the Prudent Man Award. It is awarded to the few outstanding financial professionals who have 10 or more years of experience as a true financial planner and have been recognized by their peers for the practice or promotion of prudent, qualified, and responsible client service. He holds the California Life and Annuity, Accident and Health Insurance Producer Resident License. Actually, I can go on and on tonight, and maybe perhaps the episode won't be enough to introduce and put the point how good our guest is in helping out his clients in their financial planning affairs. But let me give to you our guest for tonight, none other than, of course, the great David Kinder. David,
thank you so much for having me. Glad to be back.
Yes, I wasn't the one who interviewed you the last time, but it is an honor to have you here. And with all of your credentials, I guess I just have to let you explain how have they all helped you in assisting your clients achieve their goals.
Education and ethics, which is going to be a main theme of today's podcast, but it's all part of making sure we help clients sleep well at night. And in delivering advice, there's a lot of liability there if I'm not delivering quality advice myself. One of the reasons I pursued a lot of this education was to make sure I could be the best. And I don't mean just to be the best in terms of production. I mean being the best in terms of helping clients achieve their goals. Because if I can make sure I've always got the client's best interest at heart, and we're going to talk a lot about that phrase, but I want my clients to be better off having worked with me than before we met. And I got to make sure that I have all the relevant knowledge and experience and everything to put into place to help the clients have that in place for them. Because when I could do that for them, I sleep better at night too. So it's reciprocal. I got to make sure I take good care of them. And then by taking good care of them, yes, of course, I'm going to be taken care of. So first, my own peace of mind, as well as, of course, client introductions to others, having a, as you said earlier, a squeaky clean image. Yes, it is ideally by design. I've always been told it's not if you get sued, but when. So far, it hasn't happened. I'm very happy about that, but I am a little paranoid about some of those things, which is why I try to help as many agents and advisors to stay out of trouble. And that's a lot of what we're going to talk about today because there's some landmines, particularly in the United States. We're going to probably have more of a United States focused discussion because that's my expertise. That's where I am. I am not an expert in international laws and compliance and things like that. But how do we make sure that insurance agents, financial advisors, how are we representing ourselves to the public? How are we soliciting that business to make sure that we are upholding the best ethical standards,
Mhm.
not just helping our clients be better off, but making sure that we stay out of trouble? So it's kind of a mission of mine, quite frankly. And part of that, a little not storytelling, but a little bit of that is that here in California, over the past about 15 years, we've had two very high profile annuity cases where these agents were arrested.
Oh,
One of them was not only arrested, he was tried and convicted of grand theft.
oh,
And quite frankly, so it became a big issue. And finally, that case was overturned. Now, that was a whole big issue. That actually had nothing to do with fiduciary duty, which is what our main topic will be. But that particular agent, he was put through the ringer uh, for what he was doing. Then there was another case that was actually here locally, and this guy, he had done a lot of annuity replacements. And if you have experienced advisors with annuity replacements, and sometimes when you're replacing a contract, it incurs a charge against whatever's in there.
Mhm.
And he was doing a lot of replacements. I don't know, and I don't know the quality of his business, but apparently he was also accused of grand theft. And they talk about grand theft because these meetings happen in the client's home rather than in a business setting. And so they look at that as saying, well, you took advantage of things. And so anyway, that case was dismissed. But there's and those practices may or may not have been okay. I can't tell you. My goal is how do we stay out of trouble?
Mhm.
And there's one particular area that's been coming up in recent, especially in the financial media, is this notion of being a fiduciary. I call it the new F word, not that F word, fiduciary F word. Um, and people want to know, can I trust you? It is the biggest, and I think it's the biggest motivation behind clients asking, are you a fiduciary? And I have to appreciate the question, but what they're asking is, does the law say I can trust you? And we're looking at it from how do we respond using the law when the law may or may not apply? And here's the thing is that if you are not a fiduciary and you say that you are, that opens a whole nother can of worms too. So I want to talk about some of the nuances here. We're going to have a lot of nuances. And for everybody around the world, we appreciate you tuning in, but we're going to talk primarily about U.S. compliance law, U.S. code here. But you need to apply these principles wherever you are and do your own research. Make sure that you are operating as compliantly and as ethically as possible so that we stay out of trouble. That was a long
Wow.
answer. Okay.
It's okay. But it's hard to recover from those. two examples that you made. I doubt if they can still get back into their practice after all of those things. But you're right. It's important that you do get out of trouble so that you don't face all of these things. So,
Yes.
anyways, so why has the notion of the public working with fiduciary become so prominent in the financial media and emphasized by political figures? Why are political figures riding on it? Is it a very big problem right now in California, but particularly?
Well, I'm going back in time to about maybe 2016 or so, and there was a study done, and I'm going to butcher his name, but his name was Ted Seidel or Seidel. He is a SEC whistleblower. And
Okay.
one of the things that he did is he did a study on why do pension funds fail. And we're not talking about on the individual level. We're talking about the big company, corporate,
Oh,
or even
sure.
government pensions, whatever it is. Talk about big pensions. Why are they failing? Why are they running out of money? And essentially, what he discovered, aside from there being some internal trading issues, which that's a whole nother separate topic, we're not touching on that one. But what he noticed is that similar investments, if they would have had lower fees, the investment would have lasted longer. And we as financial professionals, we know how to do time value of money calculations. We generally know how to use something like this
Yes.
to figure out how well is an investment going to work, and we know the impact of ongoing fees. So if a fee has, and I'm going to make up some numbers. Let's suppose that an average fee might be 2%, and that's pretty common for 401k plans and other company plans, right? Maybe 2%. But if those fees were 3%, 4%, 5%, how much quicker is that balance going to go down, assuming similar investment styles, right? And so if a certain type of style of investing was averaging 15%, I'm making up a number, nothing does this. But if it's making 15% and it doesn't do 15, it does 12. Well, by comparison, the 12% one is going to decrease quicker because it wasn't earning enough. And the reason is because of the fees. And that was brought more to light. Now, one of the things that we have here in the United States, and I'm going to try to be as politically, not necessarily neutral, but politically, no, I can't even think of the word right now, but neutral is probably the best word. I want to not show my disdain for one side versus the other. So let me just put it that way. But
Okay.
there's usually and usually when you have a two-party system as the United States has,
Mhm.
we have one party that says we want individuals to make their own decisions. Hopefully, they have all the required information to make quality decisions. There's the other side that says government needs to take care of you, and we need to regulate everything to make sure that government's taking care of you. And when we look at that side of things, that side is championing the idea that, you know what, you need to always work with a fiduciary so that they tell you conflicts of interest. We'll talk about what that really means. They tell you
Mhm.
about their commissions and that you actually are going to be better off, that everything is working for you, not to you. And that's my phrasing. I call it that. And I wish that I knew that there's an exact way to always know your financial advisor is always working in your best interest. I have overanalyzed this stuff too much. There is not a single test on that. Unfortunately, I wish there was. Even a test of sincerity. You can have someone that means the best intentions to you in the world, but if they don't know anything, that's a dangerous combination. So anyway, the side of more of that collectivism, the more of government overreach and control, you can tell where my views are. But that side has taken up that that message that says these people are out to get you unless we protect you from them.
Mhm.
And we want to protect you from them by requiring that they disclose and over disclose all these things to make you second guess everything that you're being shown. Is that a good thing or not? And I have to say, it, like everything in our business, it depends, right? And that's the problem that I have.
Right.
I wish I could give a clear-cut answer to everything. But aside from the political views, there are also those that in the financial lobbyist side, because we also have both sides. We have financial lobbyists that say we want pro fiduciary requirements, and we have the other side that says we don't want a fiduciary requirement. The problem with both of these organizations is that they keep talking about best interest, and they both talk about it in the same way. So the clarity isn't there. How can financial professionals understand who's looking out for them, who's looking to do something to them? You're going to find that to be a common thing for me. How do we know what messages really mean? How do we deconstruct this stuff? So it's been plaguing me on my mind for a long time, quite frankly. And so when the last issue of the Register, Susan reached out to, hey, anybody have ideas for, an article? I thought, well, you know what? I saw what the topic was, which is ethical conduct. I'm like, I've got to write about this thing. I started writing. I wanted it to be 2 pages, maybe 3. 20 pages later, I realized this is too big for the Register. And so, with Susan's help, we turned it into a white paper instead, which actually has more authority, more credibility. And last I heard, and I don't know what the numbers are, last I heard we had 52 people that have downloaded it so far to try to just help bring clarity to what it is. And my goal for white paper is I don't want to show too much bias, right? We all have our biases, but I wanted to make sure I could show a very balanced perspective. What is one side trying to say? What is the other side trying to say? Is there a happy medium? At the same time, again, going back to it, how do we keep ourselves out of trouble? So I'm going to share my screen, and I'm going to share a little bit because one of the things that's actually confusing is that even if you've been trained with a securities license for fiduciary investment advice,
Mhm.
I remember my study materials were not that clear. So I'm going to share this. Now, here in the United States, we call it the Series 65 exam. And anybody else that's tuning in, it also happens to include the 66, which is the 63 and 65 into one exam. Just enough to confuse you. But here's the thing. It emphasizes the fiduciary responsibilities of investment advisors. It covers ethical practices, of course, fiduciary obligations. Basically, you always have to put your client's interest, their well-being ahead of your own. That makes sense. That's logical to me. The importance of acting in the best interest of clients, managing conflicts of interest, proper communication with clients, handling client funds, compensation practices. There's other things that go there. But our goal as if you are a fiduciary, especially if you have that license, you have to put the client's interest first. But what we're really talking about is this conflict of interest part. And I had clarity on this a little bit later, but let me talk about this because I had to check this with AI because I don't keep my study materials. I took those exams 20 years ago. So it's not like I'm going to go back and say, this is what it said. No, give me something sort of recent. And the conflict of interest management says advisors must disclose any potential conflicts of interest to their clients. Okay. This transparency ensures that clients are aware of any factors that might influence the advisor's recommendations. Well, my whole goal is to make sure the client's better off. So am I still clear on what a conflict of interest is or is not? Well, something else had come up in my Facebook group. Maybe some of you of the people that are listening, I do run an insurance and financial advisor Facebook group. I have over 13,000 professionals around the world in this group. Not bad. And at this point, it was a little over a year ago, we're having a pretty spirited discussion about the unauthorized practice of law. And what does it mean? And so I'm going to give a quick example of that. For example, in the UK, United Kingdom, non-attorneys can draft legal documents. They can do a trust. They can do a will and sign off as a non-attorney. In the United States, you cannot do that. But I was getting some additional information regarding unauthorized practice of law based on the topic we're talking about. And I got this, I'm going to reference my second document here, which is a Florida Bar 1993 advisory opinion regarding that. And this was really about insurance agents who were drafting trusts. And and I quote this in the white paper, and it brought so much clarity to me because it talked about conflict of interest in a different light that I think that should be talked about more. So I'm going to quote from here. The question posed by a petitioner, meaning the person that was challenging this case, also
Okay.
presents a potential conflict of interest for a lawyer employed by a corporation or other entity involved in the sale of living trusts. Could you imagine trying to work with an attorney and they had a commission goal or a production goal of how many trusts that they have to produce? Imagine working with someone like that. Like you wouldn't want to work with someone like that if you knew that they're supposed to sell 50 trusts in a month. You wouldn't want that. So I'm just throwing that as an example. Would you want someone that had that kind of not commission, but that kind of production goal to be working with you? But the decision continues. It says loyalty is an essential element in a lawyer's relationship to a client. In advising a client about the disposition of property after death, the lawyer must first determine whether a living trust is appropriate for that client. If so, the lawyer must then ensure that the living trust meets the client's needs based on how it's drafted, the wording, etc. If the lawyer is employed by a corporation selling a living trust rather than retained by the client, then the lawyer's duty of loyalty to the client could be compromised. Basically, and the Florida law says that the lawyer shall not represent a client if the lawyer's exercise of independent professional judgment in the representation of that client may be materially limited by the lawyer's responsibilities to another client or third person, like a corporation that says you need to sell a whole bunch of trusts. The lawyer shall not accept compensation for representing a client from one other than the client unless the client consents, there's no interference in the lawyer's independence of professional judgment or client-lawyer relationship, and the information relating to representation is protected. In light of this duty of loyalty to the client, a lawyer who assembles, reviews, executes, and funds a living trust document should be an independent counsel paid by the client, representing the client's interests alone. Now, I apologize for the very long-winded explanation, but what this really says is that anytime that you as an advisor are getting any kind of outside compensation, doesn't matter the amount, but if it's outside compensation, it must be disclosed and consented by the client based on duty of loyalty, because the duty of loyalty is based on the source of compensation. It was such a nice way to illustrate that, and nobody's talking about that in terms of duty of loyalty. We talk about conflicts of interest and stuff, but this really shines light on other aspects I'm sure we'll talk about. But I wanted to point that out. That's case study here in the United States. We've long forgotten it. No one talks about it. But anytime that you have any kind of commission outside of the client paying you directly, it's considered a conflict of interest. And whether it's commission, trips, merchandise, bonuses, overrides, all that stuff, all that counts.
Mhm.
And here's the thing, does it matter? The law says it matters. And so I've actually got recently I had someone an attorney here in Southern California. I was asked to make myself available to be an expert witness because this insurance agent represented himself as a fiduciary. But was he following what the fiduciary law says? Which was essentially, is he disclosing his commissions? Was he getting their consent? He's probably thinking, I've got my client's best interest at heart. I'm going to put them in a better position. But if he's not following the law of fiduciary, that could be a problem. At the same time, I think it's an additional charge in that case. I'm like, something else is amiss because usually when you get in trouble on a fiduciary level, it's like something else was really wrong. So I don't know the details of that. I wasn't called in for it. But knowing these things helps us to understand our actual duty of how we present ourselves to make sure that we're fulfilling that duty. And that was part of what I wanted to do, is to bring that clarity of our duty as an individual practitioner to light for the industry.
It's very interesting actually because I see lots of people doing lots of wrong things right now. So, anyways, now David, let's talk about conflicts of interest and transparency. Why do you think there's still so much confusion around commission disclosure, even among licensed fiduciaries? And what guidance would you give to help clarify this for advisors and clients alike?
So we need to know enough about what the requirements are so we can make sure we're meeting that fiduciary duty. Now, one of the things, and it's interesting, clients generally don't care. Let's be real. They do not care how much you get paid for selling them life insurance policy, an annuity, mutual funds, investments. They don't care. They do want to know what is the material cost to them, right? They need to know what the fees are. They need to know the terms and conditions, taxes. They need to know the material information. Clients don't care. But as a fiduciary, you're required to tell them what your compensation is, regardless. And that's one reason why I think it's easier to have these conversations with business owners than it is with the regular standard public. Okay. Now, I have looked at, because I'm kind of nosy, every once in a while, I'll look up someone's disclosure documents online. And I have a friend of mine. He actually was an early mentor of mine over 15 years ago. I worked with him in a firm, and he is now an independent uh, RIA, registered investment advisory firm. He
Mhm.
is an investment advisor representative for his firm. And I looked at his ADV Part 2. This is the compliance disclosure document. And I'm going to share with you. And I took out his name because I'm not here to embarrass him or anything like that. But it's not quite as clear as I would like to see it. So let me go into one of the other questions we might talk about is there's this suitability, there's best interest, and then there's fiduciary. And all three have slightly different standards. And only the fiduciary requires a commission disclosure. So I'm going to read this disclosure. This is like the third file that I sent here. It says, and so this is my friend's firm. He has an associate that he has that works with him. He says, one investment advisor representative of his firm. He is a licensed insurance agent. Now, the person I was talking about before, he gave up his insurance license. He doesn't sell insurance anymore. No problem. But he's letting his associate sell insurance. So he's a licensed insurance agent as well as the owner of an insurance business. As the owner of an insurance business and licensed insurance agent, he can offer insurance products to our clients and receive customary fees from insurance sales. Well, it's not a fee, it's a commission. So already that word is not quite right. So, but let's keep going. This business for this associate is independent from our firm's investment advisory services. So already he's saying it's an outside business activity. Okay. However, a conflict of interest can arise as these insurance sales create an incentive to recommend products based on the compensation earned. Good. He's disclosing. You can earn a higher compensation for making that recommendation. To mitigate this potential conflict, the associate, as a fiduciary, will act in the client's best interest. Remember, best interest and fiduciary aren't always the same thing,
Mhm.
and only recommend the purchase of an insurance product when deemed appropriate and suitable for the client. Now, wait a minute. We just conflated all three of those terms. Is it suitable? Is it best interest? Is it fiduciary? In addition, clients are under no obligation to purchase such insurance, nor is the client obligated to purchase insurance through the named associate. So here's the problem that I have. I totally trust these individuals. They have the client's best interest. They're not trying to screw anything and they're not trying to hide anything. But this disclosure does not say that they will be disclosing their compensation. It just doesn't say that. So underneath, I would add something to the effect of third-party compensation and commissions to this associate for the sale and placement of recommended insurance contracts will be disclosed and consented to by the client in the spirit of upholding fiduciary law as it comes to outside compensation. But you can see, as we've been talking about, the different nuances. Suitability is what, it is my jaded view of suitability. It's what can I get away with selling you? That I'm sorry, it's a bare minimum standard. That's my definition, but it has to be
Yeah.
appropriate, right?
Yeah.
Best interest means regardless of other standards, I'm trying to put you in the best position possible. But fiduciary has a legal connotation, and the legal connotation requires additional legal disclosures when you're going to act as a fiduciary. So when I'm looking at this, I'm like, are they going to be providing that disclosure at a fiduciary level or not? They try in this document. They're not quite there yet, in my opinion. But I'm also let's cover myself real quick. I am not a compliance person. I am not an attorney. I am pretty well versed in this stuff. I just want to see people stay out of possible trouble and harm. And if they are saying that they're going to be a fiduciary in this and they're not disclosing, technically that is a violation of fiduciary duty. And that can be a problem. But that problem probably won't come up until you have some other bigger problem that shows up later, or earlier, I should say. That would be the bigger problem that shows up, and then everything else shows up. So, as an example, I don't know if this hits around the world or not, but in recent years, especially for the past 8 years or so, the Department of Labor for the United States, the Department of Labor regulates ERISA, which is the Employee Retirement Income Securities Act. And this regulates pension plans, 401k plans, and things like that. And because of the fiduciary findings of Ted Seidel, who's the SEC whistleblower mentioned earlier, saying we want to make sure that people have the best advice, that their funds aren't going to run out. They're asserting that rollovers outside or direct transfers outside of these retirement plans should be also done by a Title I ERISA fiduciary and subject to the same code of conduct, same disclosures. And they've been trying to pass that 3 times now. Each time it hasn't gone through yet. But one of the things that has come out of it, it has been a form, and you got to love what it's called. They call it the prohibited transaction exception form, which is perfectly appropriate, as we've been talking about, right? You're not allowed to sell something that pays you a commission unless the client consents and it's disclosed. You now have a disclosure form. And so I've shared, this is a form, and it'll be on the screen here, from a company that essentially doesn't exist anymore. So that's okay. But the form is there to help disclose that you're going to earn a commission. Here's how much that commission is going to be. Here's all the terms, conditions, fees, all of that stuff that goes with it in order to meet the requirements of these laws. But here's what's interesting. The company doesn't want the form back. And why doesn't the company need the form back? Because it's your protection as an individual advisor, consultant, insurance agent. It's for your protection, your paperwork. Company doesn't care. They're not named in that lawsuit. It's on you. So, which means, when is this going to come up in a complaint situation? Well, generally, if a customer has a complaint, first thing they should be trying to do is reconcile it with the agent themselves, right?
Mm-hmm.
They should be contacting the agent. Now, unfortunately, some agents, when they know they've made an error, they're not going to pick up the phone. They're not going to respond to the email. They're not going to respond to the text messages. They're going to block them all on social media because they're a coward. Let's just call it what it is. So you got these cowards out there. They're very few and far between. At least I really hope so. The agent doesn't respond. What's the next step? The client then contacts the insurance company or mutual fund company, investment advisor firm. That's the next step. And they talk to their compliance person and they lodge a complaint. They do their own investigation. If that doesn't quite work, then the client then goes to the next part, which is your regulatory body. In the United States, it would be for insurance. This, for me, California Department of Insurance, or any other state regulator like that. For investments, we have FINRA. If it's mutual funds, we also have the SEC. Depends on what the nature is. At the conclusion of all of that, if that's still not reconciled, then the client sues and you go into either arbitration or even a jury trial. And that's when this form finally shows up. This form doesn't show up. Now, you might include it with all your paperwork. If the insurance company says, I would include it. But do they really care? Probably not until you're actually in a courtroom. And you need to make sure that you've shown that especially to a jury. One of my mentors did go through an arbitration process. This is one reason why I am paranoid. You're not paranoid if they really are out to get you. And I'm just saying that there are some people where those things may happen and those things may occur. So you've got to know your stuff. You got to have your I's dotted and T's crossed. But just because a client signs something doesn't mean they understand it.
Yes.
So one of the things that we know when we're in the insurance business, insurance contracts are contracts of adhesion, which means that the insurance company writes the contract. The client cannot refute or anything. The contract is the contract is the contract. And so if the client doesn't understand something and the client just initialed it, the law will favor the client, not the insurance company, because the insurance company, they're not changing their contract, right? So And it's up to the client, it's up to the agent to explain what the client is signing so that the client understands what they're signing. And if the client doesn't know what they're here, just sign here, just initial here. I've seen that happen before. It makes me cringe. But that's one reason why just because the client signs it doesn't mean they acknowledge and understand. They're just signing. So there's so many things that I just want to make sure that we all have the right best practices in place, that our clients know what they're doing, that they're in the right hands, that their agent is really looking out for their best interests, just to explain things and make sure that they understand why we're doing what we're doing, that we're putting them into a better position and how that works.
Great. Wow. Scary stuff, actually. But
Uh-huh. Yeah.
it's very scary. Okay. Now let's talk about regulatory and legal exposure. You made a powerful point that fiduciary duty is only enforceable in the courtroom. Should that worry people like me? Although uh, here more of the problems that we have here are uh, income tax evasion, things like that. Those are the things that that insurance advisors, insurance professionals worry about here. But this is really the next level stuff. So should we, as financial professionals, worry about this? Uh, well, especially us here in the Philippines. Well, I heard that the insurance commission here, well, most of us members of IARC here are part of the life insurance industry. They're slowly getting there, actually. So should we start worrying about it and start preparing for it?
My unequivocal answer is yes, yes, yes. And how do we make sure of that? Is that we got to document, document, document. You've got to take notes. You've got to even prepare your own reports that help translate legalese or disclosure speak to make sure that the consumer can understand what they have and the consequences of the decisions that they've made. In fact, one of the things, in fact, I mentioned the political sides, and I actually put a link on this in the white paper. And this particular senator said that these disclosures are often written at an above college graduate level.
Oh,
And, and like when they're that opaque, when they're not that understandable, sometimes it just makes sense. Write out a document that says if you take out more than this amount in a given year, you're going to be hit with a fee. Now, we're not planning that you're going to need to do that, but if you need to, this is what's going to happen, right? We got to make sure that clients understand and that we understand enough about the client that we put them in the right position. I don't want a client that says, I have $500,000, but I need 400,000 next year. I'm buying a home. And that person somehow, I'm making this up, somehow that person puts 500,000 into an annuity. Now, that is malpractice. I don't care what your disclosures are. You just put more than 400,000. They need 400,000. You put 500,000 into an annuity, and if they want to get access to it, if it's an 8% charge, you're looking at what, 35,000 of a chargeback, and a surrender. You're talking about big dollars that you, the agent, caused because we didn't listen enough. Now that is, to me, that's criminal. And that part, sorry, I almost think you got to go to jail. Not just pay fines, you got to go to jail just because you did that purely for your own enrichment. Some of these cases are so cut and dry like that. You look at it and like, yeah, you're an idiot. What did you do that for? I see other cases like that where, and by the way, something that's interesting here in the United States, sometimes people will be barred from offering investments and securities, but yet they'll still be able to keep their insurance license. I don't know how that works. It's two different regulatory bodies, but they'll be barred from securities for doing a lot of bad stuff, and yet they still have a life insurance license. And they can still do a lot of harm just with that license. It's still possible. But the main thing is that one of my mentors told me, it's not if he gets sued, it's when. And with that in mind, you got to have good notes. And so have some kind of contact management system, some type of client file system Every time that you talk to the client, you're making a note, date, time. Here's what we talked about. If you sense a client is taking out too much money, we had this situation many years ago. The client was taking out way too much money out of their annuity, and they're incurring surrender charges. And now, I also believe we're not their papa, right? I'm not supposed to keep you out of harm's way. I'm supposed to disclose to you that you're spending too much money too quickly. We document our files. It's not our job to make them not do their own bad behaviors. That's on them.
Mhm.
But you got to document that you've warned them. And that, from what I understand, because some time ago, that person took out all of their money out of their annuity in 2.5 years. We think that there might have been a gambling problem. So that could be an issue. They could go through all of that, but that doesn't mean we didn't disclose. Our job is to make sure that they understand the consequences of their decisions. So, which actually brings me to another point, which is how do we answer the question, are you a fiduciary? Because we're being trained, the consumers are being trained to ask that question. They want to know, am I going to be in good hands working with you? Does the law say I can trust you? So if you are a fiduciary in everything you do, you got the easy response. Your answer is yes. Here's my disclosures. You're all set. And you just got to make sure you're following through. If you have dual licensing, where you are a fiduciary in one capacity versus not in another, look, I'm not that smart. I don't know how to say, I'm going to screw you. No, you're not. But I could take advantage of you with one way and then have your best interest. I don't know how to do that. But you could say I'm a fiduciary on an account level by engagement agreement on a fee basis. But in other areas, we're going to treat you right. We're going to make sure that it's all going to fit for you, but it's a little bit different. You just got to show differentiation, but you want them to realize that you're going to exercise discretion and proper care and judgment, that it's going to be on their behalf.
Mhm.
If you are not a fiduciary in any capacity, so if you're an insurance agent, and unless you're saying you're an insurance agent, that's a fiduciary. But if you're not a fiduciary, here's my response, and I happen to really like this. I consider myself a fiduciary educator. My job is to help you understand the consequences of the wealth building decisions you've made. What are your choices and the consequences going forward? And to make sure that you can make the best decisions possible. Because what people really want to know, and I don't care what standard you operate under, at least that the law says, we want our clients to be better off having worked with us than without. And we want them to be better off now that they work with us than before they met with us. I want them to feel that I am going to look out for them. But yet, if you're going to say, does the law say, no, I'm going to take care of you. I want to help you be the best we can. And I got this wording for someone else. I really like it. Help you make the educated financial decisions that feel right to you, including doing nothing, if that's what feels right. I want to help you maximize your potential, minimize mistakes and risks. That's my message. And as long as I can do that and I can show and demonstrate that I'm trying to do this for them, not to them, that's the quality message. So I might co-opt that term fiduciary as a fiduciary educator, but the whole goal is, where have you been? Where are we going? What's the best course of action that we can get you there? Do you want to move forward? And I think that's the best spirit of that. That's also not going to tie you down with a whole lot of disclosures if you don't have to. So those are my thoughts there. Because people want to know, are you going to take care of them? And it's a bad feeling when we feel like we have to backpedal and say, well, I'm not a fiduciary. I earn commissions and this is how it. No. We want to come out with power, sincerity, and let your heart show through. That's far more important. And you got to have that confidence in yourself that you are going to take care of them, regardless of whatever standard. In fact, I shared this at the financial forum. If you, as a financial advisor, financial consultant, insurance, if you need the law to tell you to take care of people, then you suck as a human being and get out of the business. Okay, we don't need the law to tell us to take care of people, but if you need the law to tell you to take care of people, just get out of the business. Go do something else. Open a Taco Bell. Or you're in the Philippines, open a Jollibee's, right? I mean, do something else. Don't be in the financial advice business if you need the law to tell you to take care of people.
Okay. those are great words that you shared, David. But here, here in the Philippines, we loosely use a lot of titles and claim ourselves as experts. So would using the words like recommendation really that risky? And why do you advise against it?
It can be risky. It might not be. And in a way, I'm splitting hairs. But let's talk about that because here's the thing. I want people to buy as opposed for me to sell.
Mhm.
Now, when I'm thinking about to sell, and it's interesting, the word sales is not seen as a professional endeavor. They don't
Mhm.
see you as a professional. They see you as a peddler. They see you as a huckster, someone who's trying to get your way, regardless of whether it's good for the other person or not.
Mhm.
I don't like that, but let's look at reality. We can either fight it or work with it. And when we're looking at the word selling, sometimes you can put the word assault in there. He sold me. He assaulted me. It could have the same connotation. And so when I'm making a recommendation, sometimes we think of it as being a doctor. I recommend you cut out your salt. I recommend you start, make doing some walks around the block, 3 times a day. We think of it like a doctor, but then we're also imposing our value on that. I want them to buy. I want them to say, I want this, which basically means I'm going to propose. Here's one strategy, and you can keep going on that path if you want, or here's another way. Now, when I propose it that way, I want them to say, yes, that's the one I want, which means that they bought. I like that nuance. In a court of law, would it really matter that much? Probably not, because I still earned my compensation regardless of whatever it is. But using the word recommend is you have to be very careful, especially when you're an insurance only agent and you're working with somebody, and let's say they have securities in a 401k retirement plan, and they want to move it to something that has safety, security, and guarantees. You
Mhm.
cannot say, I recommend you move this money from there to here because of the risk you have over there or because of these holdings. Now you're giving securities advice. And when you're doing that, that is a direct violation of securities law. You cannot do that. You've got to be very careful on your wording. If someone says, how much of my retirement plan should I put into this? My answer would be more along the lines of, if you want this benefit, we need this much to fund it. If you're going to ask me which securities to liquidate, I cannot give you advice on that. You
Mhm.
can, and for there, you can do it pro rata, which means equal amount from each portion, to make it up, or you contact them and you could get help from their 1-800 number, from, 1-800 no help is what we used to call it. Because they can tell you what you can do, they just don't give
Yeah.
you advice on what to do. Uh, but as far as titles and such, we're still going through some of that discussion here in the United States. And it's to me, I don't want to be known as an insurance agent. And the reason I don't want to be known as an insurance agent is because that's being known by the product I sell, not the problems that I solve.
Oh.
So I happen to really like being a member of the IARFC because it allows me as one additional designation to brand myself as a consultant as opposed to being branded by what I sell. It's one of the most ethical workarounds in order to present yourself properly. I don't want to be known, I mean, imagine this, and I love sharing this example. If I'm at a networking event or a church event or something like that, and I introduce myself, I say, I'm David Kina with New York Life. There's only two possible favorable outcomes I can get, and not the third. The first one is, can you save me money on my current coverage? Okay. Yeah, maybe you might be able to get that sale. The second one is, can you get me coverage? Because they're sick, right? They have a condition. The third one won't happen with that positioning. They will not say, can you set aside 30 minutes to show me why it's in my best interest to put five, six, seven figures a year into cash value life insurance? That's not going to happen that way. When we were looking at the proper order of making a presentation, I don't want to lead with my product because I'm leaving it up to them and what they think it means to them based on what they know. What is the general population's understanding of how life insurance works? On a scale of 1 to 10, -5. They don't understand it. Why would I lead with a product that the public doesn't understand? So I don't. Um, how many agents understand it? At least it's a little bit better. It's probably a 1 out of 10. I mean, on that scale. So I don't want to lead with something that people are confused about and maybe even be afraid to talk about. I want to talk about what are the problems that you have right now that I can help solve using my expertise and the products and solutions that I have. And that's when the life insurance shows up. The best appointment, the best ending, the conclusion to a client appointment is when the client is ready to make out the check. Yeah, the checkbooks, we used to have those things. And they're asking, who do I make the check out to? Do I make it out to you? And you have to stop them and say, no, don't make it out to me. I'm not going to jail. I want you to make it out to the company because you're getting the coverage from them. That's the perfect one because the company doesn't matter. And that's different in the Philippines because you told me earlier that you can only represent one company at a time. That's a whole different thing. In the United States, I can represent multiple companies, almost as many as I want. Keep in mind that the more companies you represent, the greater your exposure is. Remember, we talked about legal liability. How can you be an expert in 30 different company products? You can't. So I like keeping it very minimal and I'll deviate as necessary. I have 4 main companies, and of those 4, 3 are life insurance companies, and they have different nuances. And the other ones are a couple of annuity companies. And again, they have different nuances. I want to keep it focused because I want to make sure I'm always as a quality of an expert as I can on what I'm offering. But you also mentioned the word expert. So expert has a legal connotation. And especially here in the United States. For example, years ago, there was an organization, they offered a certification called Board Certified in Estate Planning. What they didn't know is that in order to be called board certified, you had to pass a rigorous legal law exam in that topic. Once they brought it up to them, they changed the name and the branding of that. They now call it Certified Estate and Trust Specialist. So they did a complete reshifting. And so even for attorneys, at least in the United States, to call yourself an expert in law, you have to be considered board certified in most of the states here. So that's a whole nother level. If you call yourself an expert, especially on LinkedIn, where we have the most of the liars on there, because whenever I connect with someone, they have expert in one of their headlines and their titles. I let them know. It's like, you know what? You might not want to have that there. In the event of a complaint, that attorney, whoever's going to be prosecuting you, they've already downloaded this. They've got all of your other materials, and you're going to say that you're an expert, and they're going to quiz you on the stand to make sure you really are an expert. And so I've already seen, in fact, I have it on my YouTube channel. I should send you the link later. I have a whole series with Steve Savant. His real name was Steve Schneider, but he was interviewing Ilya Lerma, a prosecuting attorney, and she sues insurance agents.
Wow.
And we're learning from her what are some of the questions that she's asking. And she finds it odd that, and talk about property casualty insurance, there's agents that don't know how to define what liability means without using liability in a sentence. I'm like, wow, that's a little dangerous. And so knowing how are they going to build that case against you, if you call yourself an expert, that will be used against you. In the white paper, I talk about a couple of cases, and we're talking about how that, especially one agent, how he represented himself to the public. And they even talk about, is this designation accredited? Is this all this other minutia stuff? They built in this case to be able to say this person was out to get you. And no one wants to go through arbitration like that. So you really want to make sure that you cover yourself. And so the word expert, has that connotation, you got to be very careful of using that term. I advise anyone, unless you're ready to be put on a witness stand today and asked any question about anything in your profession, and especially the insurance code or investment code, whatever it's going to be, unless you're ready for that, I would not put that in there. And why increase your liability if you don't have to? When you're an insurance agent, you're in the risk transfer business. You're in the risk management business. Why would I increase my risk in my profession? I don't want to increase it any more than necessary. Anybody that goes to my website, you already read my bio and stuff from earlier. In fact, you truncated it, which is fine because I don't need to go through the whole thing. I already present myself as an expert without using the word. I don't need to use the word. I could already show I know my stuff. My goal is to put people in a better position. But I'm not going to increase my liability if I don't have to.
So we really have to be careful. We're not yet, I don't think our government is still at that level, but I think they're trying to get there. That's part of, I guess, the things that are going here because of our links with the ASEAN economic community and all. So the regulators are somewhat leveling up how they manage their respective industry. And
Mm-hmm.
anyways, so David, if a consumer is listening to this and wondering, can I trust my advisor? What would you want them to know? What are the things and points or ideas that would perhaps help them ask this question better and investigate further their advisor?
It's a loaded question, and I wish it wasn't. I wish there was a very clear-cut way to answer it. I have one idea here, and I'll get to it in a moment, but some of the things that I've discovered is that designations are not the only way. I like
Mm.
to think it is a symbol of quality. I have designations after my name. You have designations after your name. And we like to think that, yes, we're holding ourselves at a higher standard. And yet, some people make up their own designations. And so, unless there's consumer awareness on what those things mean, does it really matter? Maybe not. Association membership. Well, I do like the fact that if I don't take care of the client right, yes, the IARC will kick me out. I get that.
Mhm.
But do we have to wait? The problem is I don't want to with the consumer to have to wait for me to get kicked out to realize that I was a bad advisor, right? Or anybody else. I'm using me as a scapegoat in a way, just because I don't mind that. Is it because that they have one license over another? Well, remember, the biggest Ponzi scheme of history was Bernie Madoff, and he was a fiduciary. He had all the credentials you'd want in the world. The main thing, and when you look at, can I trust their heart? Well, heart without knowledge is dangerous, but then knowledge without heart is also dangerous. The biggest test that I can think of, and I pride myself in doing this, is that whenever you're working with someone and they're talking about financial concepts, that they will tell you what the downfalls can be and how they're factored into your situation. So, for example, we talked about annuities earlier, right? If you take out too much, you're going to get a surrender charge. It's a big charge depending on the year that you do this higher withdrawal. Well, if you're not planning on taking out that withdrawal, it doesn't matter. But we got to make sure that if you do know that, this is the consequence. That doesn't make the annuity a bad product. It means you need to know the consequences. If someone is only talking about the greatest things in the world about their product or their course or whatever else, and they're not talking about the downsides, you don't have an advisor. You have a peddler. You have a salesman who's trying to win one over on you because there's no such thing as a perfect product. There's no such thing as a perfect strategy. An advisor will take the time to make sure that you understand the pros and the cons. So, as another example, we talked about annuities. Another one is life insurance. Life insurance is not an investment unless it is what we call a variable contract and it happens to contain securities. There's a difference there. But if someone says my life insurance will outperform your investment, whoa, you better be able to know what properties you're talking about that. Now, I know how to say that and know how that works. I can show how having $1 in life insurance in the United States, I'm going to clarify that. In the United States, I can do this. $1 in life insurance for retirement purposes will spend better than $3 to $5 in a retirement plan. I can show that and do the math. But notice that I'm not saying that it will perform better. You will not have a higher balance in the life insurance. I actually said you'll have less money, but it will do for you better. It will perform better in terms of income or cash flow generated in retirement than having all that money in the 401k or other retirement plan. It's so critical that we're very cautious of how we're representing ourselves. I don't like saying that life insurance will do better. It won't in most cases. And if I can own that and communicate that value, I can say you're not going to have as much money, but it will do more for you because of where it is, where your money is, more than what it earns. But you got to be able to substantiate that. I can do that. Not everybody can. So many people like to say, my life insurance will do better than your investments. That's dangerous territory. You've got to be really careful. What are the assumptions on all that? And should you be making that comparison? Some people say, your life insurance should not be your investment portfolio, and your investment portfolio shouldn't be your life insurance. Well, sometimes you can mix them together. It depends. But someone that's so hyped up on their product, you've got to stop and ask yourself, are they trying to get one over on me? Because they're not telling me anything of the downside. They're not doing any proper disclosure. They're not telling me that if I don't keep this thing funded, that I could lose all of my savings. They're not disclosing all the downsides. And a true advisor will do that. That's one of the reasons why I mentioned earlier. Is your advisor doing this for you or to you? And I think the biggest thing is that if they want to do it to you, they're going to stick it to you. They're not going to talk about any of the downsides. They're not going to be an advisor. They're just trying to make a sale. I think that's the biggest differentiator, because a true advisor will take the time.
They will explain everything that will affect the client, basically, right?
Yes.
Well, let me ask you this. If a fellow advisor is listening, and we do have, or watching us right now, there are many members of IARC Philippines who will be watching this episode. What's your best advice for staying compliant, transparent, and competitive in an ever-changing regulatory environment? It always adapts. It always changes because of the things that are going on, right? So how do we join, or how do we go be part of the change and adapt to it so that we remain relevant to our clients?
Well, the first part, we got to look at first our own practice protection. You got to document everything. And, whether you're doing a formal fact find or discovery questionnaire, or it's just on a we call it a writing tablet, whatever it is, you've got to be able to document that you've understood the client. Where are they at today? What do they want to accomplish? You got to keep those notes. You got to have a filing system or a contact management system. You've got to document everything. That's the biggest thing, because if and when a complaint shows up, if you don't have anything to show up, for your files, it's probably going to be a summary judgment against you, which means you lost. So we got to make sure we're always on top of it. And that's timeless. Now, there's other parts of that, which is, are you having your text messages archived and such? You might need to do that too. I would do screenshots where you can include that in the client file. So if you're texting with someone, screenshot it, put it in the file that says you talked about this. And if you're not supposed to have those conversations in text message, say email or call my office or set up an appointment, have the conversations in the proper place. Because we've actually had cases where securities licensed representatives are having conversations on places where they're not being supervised, and those conversations aren't being archived. So that's an important part. You just got to know your rules, laws, and regulations. stay on top of your forms, but usually the companies are good at sending you the right forms. So if you're using electronic applications, that's perfect because it should be update, right? If they say this form is updated as of today, it should be in the documents when you're doing a new application. Not a problem. But the life insurance application or the annuity application, that is not enough. You need your own file notes. You need all of your correspondence. Put that all in there. You've got to have that track record. The person who generally has the most notes is going to at least prevail at some way if you had to go to a court or if you had a complaint situation. When you could say, here's my notes, if you've got a stack of notes, you can say, here, have at it. The client says, you misled me. Here's all the notes. Here's all the disclosures. Here's all the documentation. You want to be on the winning side of that. And quite frankly, you want all the weight of that as much as possible. Yes, it'll be electronically filed, but if you've got 50 or 100 pages of notes on the client, let them scour through it all. You did your part. You disclosed everything properly. You're keeping everything up to date. At the same time, client reviews. Stay in proactive contact with your client. They should be hearing from you at least once a year just for a casual conversation. It's like we got to pretend like we like our clients after they bought, right?
Well, we should really like them.
We should like them. That's not being the witness protection program. I mean, we want them to know that we're still around. One of my favorite ways to do that, by the way, is send them a personal newsletter. Now, here's what I mean by that. Give them an update in your personal life and your professional life. Talk about what's going on with you. So we're not talking about the stock markets. We're not talking about product. We're not talking about, no, talk about your professional development. You got to talk about that you're taking additional courses, that you had some speaking engagements, that you're doing a seminar on something. You can talk about your family, your kids, and what's going on in your life. So you make it personal, and you'd be surprised how many people will respond back to you that says, "Hey, David, great job. I'm so glad that you're doing this part." Last year, I think mine was 5 pages that I sent. In fact, I didn't think of bringing it. I will send it to you so you have it in the document, so you have an example of it. But I had I sent out this newsletter, and people are responding just to keep in touch, have a conversation. You know, it's a beautiful thing. And so make business personal too. And believe me, your clients want to see you be successful. Now, there's a caveat to that. They don't necessarily want to see you driving a Rolls Royce and have a 30 square foot mansion, but they do want to see you survive and thrive because the more successful you are, the more people you can help.
Yes.
And that shows that you are being successful in the people you're helping. Who else can I help? And so all of that all fits there. I think I went off on a tangent, but the thing is that the best way to help our clients is, for advisors, keep in contact with your clients. It's one of the best things. And because when a client gets to the point where they're starting to think about that, if they've got a complaint, if they're getting to the point where they've got to contact a regulator or they're contacting your compliance department of your firms, it's because they feel betrayed and ignored.
Mm-hmm.
And if they feel a betrayal in the relationship, and believe me, an attorney will take that step. They will claim that you betrayed the relationship just by not answering your phone. Now, I'm not talking about the one-time thing. If you're having dinner with your family, your client calls, let it go to voicemail. Get to them in a reasonable time, but you're not going to completely ignore them, right? Because if you're ignoring them because you're afraid that they're calling, it's only going to be a bigger problem later. Keep in contact. Own your problems. If you created a problem, you better come clean. Clients are understandable, especially when we are proactive. If you created an error, and I'm not perfect, but I haven't created any big enough errors that have warranted this. So I don't have any experience with this. But the biggest thing that you can do is be a human being, admit something didn't quite go right. I'm going to work to fix it. I wanted to let you know up front. A client can only appreciate that you're taking personal accountability, not that you're saying, now, keep in mind, also think of it like when you're in a car accident, you don't want to admit fault. You don't want to do that when the police are there, for a car accident. So you don't necessarily want to admit, oh my gosh, I completely messed up. You want to say, I noticed a situation. I'm working to get it fixed. I might need your help. I might need you to sign something or something because I need to get this right because it's not right now. A client can only appreciate that. This is a way that you're showing that you're taking care of them. Even though you didn't do it right the first time, you're trying to correct it. A client can only appreciate all of your efforts in doing that. And you got to do whatever it takes. And even if you can't get it corrected, what can you do different? What can you do to add to their program or something? Whatever it is, you got to find a way to make it right, especially when you created an error. Whatever you got to do, and document your files that you did all of it. So,
Yes.
but we've just got to be decent human beings, right? We
Yeah,
take
correct.
care of
That's
things
it,
and be
actually.
on top of it. This is why there's some people that have gone through their entire career, never had a regulatory complaint. Why?
Correct.
They take
Correct.
personal accountability and response.
You
That's all it
do to
takes.
others what you want others to do unto you, basically.
Yes.
Yeah. But you pointed out a lot of interesting stuff. These are next level discussions, but I appreciate it. And for sure, people watching this podcast also appreciate it. How can they learn more about your work, David? How can they read your white papers, or how do they connect directly to you? How can they reach out?
Well, for me, my website is www.davidkinderfinancial.com. Exactly how it sounds. You can, of
Okay.
course, find me on the IARFC website. My profile is there. They can reach out. Um, for our members, we've got the virtual summit coming up, my third year. Although, no,
Wow.
we're not looking to replace it, but I am adding a co-host. So,
Okay.
we're shifting it up just a little bit. But we have the virtual summit coming up in what, 6 weeks? No, a little bit longer. Um, but this is for practitioners
Okay.
to learn how to get better. Just a couple of nuanced ideas is perfect for that. And obviously, if you're not an IARC member, but you are a licensed professional, come on in and join us. The water's fine. We're not going to bite.
Wow.
And yes, you are going to hear why you really should be a member. But at the same time, even if you're not going to join, you're going to get so much out of this. And this will be my third year hosting it. The best thing I love about it, because I've done a number of these webinars, I've done it for the past couple of years. I get to ask any question I want.
Wow. Okay.
So
So you
that's
have
the
a free
best thing.
license to ask anything.
I can ask anything I want. And so, yeah, and by the way, we are hosting this free. This is a
Oh,
member benefit. This is free for the industry. This is our way of getting our message out. Come on and join us. It's what,
nice.
10 hours total? No, I can't remember what the number is, but you have to register. And so we'll get the link out so everybody can register and everything for that. But the neat thing, when I can ask any question I want, I've had one-on-one time with the number one agent in the world. And I don't know if he speaks in the Philippines, but Dr. Sanjay Tolani.
Oh
I've had
yeah, yeah.
one-on-one time with him. The guy is amazing, and I get mesmerized just by talking with him. And I had one-on-one time, and an hour into it, I swear I had the greatest career realization that one could ask. And the realization was that all top producers all do the same things. Now, they do it according to their own style, their own market, their own message, but they understand the principles of success and they employ them and they have that confidence. Once I understood that, because he brings such simplicity to the way he communicates. The difference is he's doing it on a government level, a royal family level, on a very
Oh,
high, ultra high net worth level. I don't even know if ultra is the best term because he does things at this really high level. But when I understand that the principles are all the same, it was the greatest relief that I could understand. And you can only get that kind of realization from conversing with someone at his caliber. Because you can talk to a lot of other people that are, and I hate to use the term, good, but average producers. You think, well, that's you. Someone else might have something else. When you go that high up, he did 320, I think it's 327 times top of the table MDRT
yeah,
production last
yeah.
year. That's almost top of the table every single calendar day. I'm like,
Exactly.
I don't aspire to be that good, but I'm like, I'm glad someone like that exists, and I could call him my friend, and I can ask him any question I want. And so the realizations of being able to have that clarity is beautiful. Um, but yeah, that's one of the reasons why I like hosting it. I get to ask any question I want.
That's
Um,
fantastic.
and usually when I'm asking a question, it's not very technical. We've talked a lot of technicalities, hopefully in a high level
Mhm.
to shows that, to bring it down for all of us that aren't studying tax code and compliance code. The goal for me is if I'm a student, and I consider myself a student of the business, I always will be. And if I'm representing the audience, I want to ask them the question that might be on their mind, to bring that clarity because I want that clarity. I want to learn from all these people. So yeah, I've got the front row seat and it's great. And sometimes, and we do have a lot of fun with it, but the realizations that we can get, top notch, just amazing. So yeah, join us for the virtual summit. That's where you can see if they're on Facebook. I have the Facebook group.
Mhm.
It's nice. Facebook.com/groups/life insurance. That's the group. Um,
Great. We're actually posting the QR code. So, guys, it's an open invitation for as long as you are a financial services professional. Do join the virtual conference. Again, David, we learned a lot. Thank you for inviting us in joining that virtual convention or conference. We're looking forward for it. Definitely will. I'm sure with what we've heard and saw tonight, we will be learning a lot more things. And the way you ask questions, for sure, you'll bring up a lot of good ideas that will help us level up our practice here in this side of the world. So thank you for your time. Thank you for your wisdom. And thank you for sharing all of your experience.
my
Okay.
pleasure.
This has been one of the exhilarating episodes of our podcast series. I'm sure a lot of RFCs and viewers are now more keen in making a difference in their financial planning career, especially in our fiduciary responsibilities to our clients as registered financial consultants. And David pointed out a lot of important stuff here. Basically, when we practice, it's important that we treat our clients as we would want them to treat us. So it's a basic human rule to do what is right. So as he mentioned, if you do things right at the onset, it would it would not lead you to any problems later on. So might as well do it right the first time. We also truly appreciate the excellent efforts of Susan Kappa, the IARC Public Relations Officer, for ensuring the success of this international series. Again, our many thanks, Susan, for doing the backroom work and the admin stuff in setting up this international series. I would just like to remind everyone that active members now receive free continuing education seminars and access to the official IARC website, www.iarc.org, where each member of good standing is recognized when searched by clients and prospects. Please do be reminded that we can only use the RFC designation if we are members of good standing. For your membership renewal information, please do contact Ms. Grace De Vera Escobar at g.escobar@iarc.org or through her mobile number 0917-157-7523. So contact IARC Philippines now for your membership renewals. I would like to remind everyone that our podcast episodes are shown every second and fourth Tuesday of the month. And that is why it is very important to follow us on Facebook. Episodes are pre-recorded and are broadcasted through Facebook Live. On behalf of our executive producer, Ms. Grace De Vera Escobar, this is the RFC Tuesday podcast saying,
It's better to be in the know than to be the last to know.
thank you so much, everyone. Good evening, and do please stay safe. Good night.